Good morning. So I'm assuming we're going to get some indication that people are logged in and here. Let's see. Yep, the number is going up. We'll give everybody a minute to log in and then we'll get going.
Taylor Collins just said, looking good.
Thank you, Taylor. Wonder if she's got Jim under control today.
That never happens.
Right. Let's see. Looks like we're up to 43 participants and counting. Give it another minute and then don't keep going. I just answered. I heard that. Great. Well, it looks like we're up to 44. Why don't we get going, and then since we have some intros and some housekeeping and whatnot, then as folks matriculate, then hopefully that'll be for the meat of the session. Everybody, I believe, is on mute. That doesn't mean we don't want your questions. Please use the Q&A function versus chat. So anything that comes to mind, if you want to play Stump the Attorney, that's your opportunity to do so. We'll try to get to those questions, or at least the concepts that you're hitting on. In the meantime, I'm Tom Lazier. I'm a board certified real estate attorney, and I'm a partner in the real estate section of Williams Partner, moderating today. And I'm joined by three incredible panelists, all accomplished in their own right. My partner, Liz Stamoulis, heads up our intellectual property practice at Williams Parker, advises all forms of businesses and corporate and internet and IP issues. She was recently named to the Business Observer's 40 Under 40 list and is a Florida super lawyer rising star. Welcome, Liz. Also, Jennifer Fowler Hermes, my partner who heads up our labor and employment section. She's board certified in that subject, represents all sizes and forms of businesses, regularly named to the Florida super lawyer list for labor and employment litigation. Welcome, Jennifer. And also our good friend Kathy Hargraves with Corcoran Barberio. Kathy is a CPA as well as a certified financial planner. Kathy leads the healthcare consultants group at KB, advises all sizes and stripe of business in tax matters, payroll, entity selection, etc. So welcome to all three of you. You all are standouts in your field and are going to give some excellent insight today. So the reason we're here, during the pandemonium of the pandemic, I think anyone in professional services has been in reaction mode, trying to assist their clients who are being impacted by business shutdowns and furloughs and whatnot. Then you layer in PPP and changes in tax regulations and whatnot. And the only thing that's certain is the uncertainty in the landscape. However, we started getting calls from folks who saw opportunity and wanted to start new businesses. And we also saw folks who were having these unanticipated upticks in their businesses. And we started thinking to ourselves, it's always good to have your house in order and make sure that you've set your business up right and you're set for success. Or even if you're further along the curve, it's important to take a look at what the background looks like and make sure that you're set now more so than ever. And so that's how this came together. And with that, I'm going to start off with Liz. Liz, talk a little bit about the necessity of forming an entity. I know that sometimes you'll have a conversation with a client and they kind of take the approach that forming the entity is just a way for the lawyer and the state to make some money. It really goes beyond that. So talk generally, if you would, about why that's important.
Sure. So thank you, Tom. Good to have everyone here with us today. So I do get a lot of questions. People ask, do I need to form a company? Can't I just operate my business on my own? And yes, you can, but from a legal perspective, there are some benefits to forming an entity. And I do want to say I'm only talking from a legal perspective here. I know Kathy has some tax considerations she's going to talk about. So if you operate your business by yourself without an entity, generally speaking, if somebody has a claim against the company, they would have a claim against you individually, and all of your assets that you own personally could potentially be available as a remedy to them. So on the legal side, we would recommend that you form an entity that can provide some liability protection. So that means that if you form a company and you treat it like a company, you run it properly, capitalize it properly, generally at the end of the day, if someone has a claim against the company, it would be against the company. They wouldn't be able to reach through to you and grab your individual assets. I want to put an asterisk here. That doesn't mean that forming a company prevents you from having any liability in all circumstances. Just like you normally do in the world, walking around, have liability for your own acts of negligence or other wrongful conduct. If you do that through a company, you could have liability as well. But generally speaking, if the company is entering into contracts on its own and acting like a company, if it were to breach a contract and somebody were to sue it, they would be limited to the assets within the company and wouldn't have access to your personal assets. So that's one of the big benefits of forming an entity. Some other things to consider are forming an entity gives you an easy way to share ownership among multiple people. If you own everything individually, then it can be hard to split it up. If you want to bring in a partner, how do they own the assets? But if you put it all into an entity, that gives you a vehicle to now share ownership. You have units or shares that you can divide up between people. And that also gives you the opportunity to address the relationship between the owners. So what are your responsibilities and obligations to each other? How do you act day to day within the business? That can all be handled through the entity documents. And the last thing I want to mention is it's helpful to think about this up front. We often have people come to us in the middle and we can help them with that, form the entity. But then you have now all of the assets you've accumulated personally, all of the contractual rights, all of the intellectual property rights, and making sure it all gets assigned over properly can be difficult. And if the end game is ultimately to sell, a buyer is certainly going to want to see that all of those documents are in place, make sure the chain of title is there, make sure everything's clean, that the entity actually owns everything it's supposed to at the end of the day. So I would say sooner rather than later, just get everything locked up so that you're ready for the future.
Got
Hey,
it.
Liz and Tom, I just want to add that so many of our clients bring us their tax work. They've done their own thing on the internet. They don't understand their entity. They don't have operating agreements, and particularly partnership agreements.
Right.
And if things go south, they don't know how to defend that. And really, we don't know how to prepare their tax return unless we have clear guidance, and we need that really from their documents.
I was going to say, Kathy, that kind of gets in. I'm sorry, that kind of gets into that interesting interplay between the CPA and the attorney. The client will be saying, "Hey, I want to set up an entity. What entity should I select?" And so then you get the answer from the attorney saying, "Well, we're concerned about liability issues, but there are tax ramifications potentially depending on what you select. So we should involve your CPA." So what's your take on that when someone comes to you and says, "What should I select? What should I set up?"
Yeah, that's a great question, because it's really important to figure out what kind of entity you want from a tax perspective.
Right.
But that's taxation,
Mm-hmm.
and it doesn't fall equally into entity selection. There are some corollaries, but we need to figure out your business model, what you're doing currently, what you think you're going to be doing in 5 years, whether you're a person who's going to take on employees, other individuals as partners or shareholders, whether you think you're going to have a complex business, whether you're starting a complex business. So we're looking at taxation issues, but for instance, a partnership can be taxed as a partnership. We call it partnership, but they're an LLC. We also have an LLC entity that's taxed as an S corporation. Those are very common. Or you can have an LLC that's a sole proprietor. So with one type of entity, which the attorneys hopefully are setting up, we have 3 different tax choices. They're all unique. They all depend on your own facts and circumstances. Right. But it's conversation that really needs to be had with all the advisors involved at the beginning.
Real collaborative effort, in other words.
Yes.
So you mentioned the E word, employees. And so I started to think about that overnight. I thought, gosh, like Jennifer, like how do you even step off on that subject? I think a lot of people throw around the term Florida is an at-will employment state. So I think they figure, why do I need Jennifer? What kind of advice do I need? But I guess the initial question is probably who are your workers going to be? How are they going to be paid? What's at will versus non-exempt? Can you give us kind of a broad brushstroke picture of what it looks like at the front end if you're going to hire somebody?
So when you're starting a business, a lot of times individuals start out on their own, just themselves or maybe one partner. But most businesses anticipate growth. And when you anticipate growth, part of your plan should be when we need more people, or if you are actually starting out with others helping you that are not owners, it's a good idea to understand what type of work are these individuals going to do. Do we expect that we are going to control the time and the manner in which they perform the work? How are these individuals going to be paid? And that's a very important analysis, because although it is an at-will employment state, which basically means that either the employee or the employer can terminate the relationship for any reason, provided it's not statutorily prohibited, there are a lot of statutorily prohibited reasons. Title VII, Florida Civil Rights Act, you can't terminate somebody because of their race, their religion, their sex. It doesn't apply to all employers, but if we anticipate growth and we anticipate being successful, sooner or later, these laws are going to apply. And when they do, we need to be ready. We need to have managers trained, and we need to understand what exactly we need to do to protect ourselves from potential liability. In addition to that, there are many other laws that don't deal with discrimination that apply to employees, i.e. OSHA. Are you keeping your workplace safe? The Fair Labor Standards Act. Are you paying minimum wage? Are you providing overtime for those that are required? And when you're taking a look at that, a lot of individuals who have not started businesses before are like, well, I'll just make them salaried, so then I don't have to worry about it. Well, it's not that simple. The exemption from overtime attaches to what the individual's doing. And although being salaried in some of the exemptions to the law is a requirement, it's not the only requirement, and by itself, it's not sufficient. In addition to that, there's making sure that you have proper workers' comp coverage, that you're doing the proper reports to unemployment. There's a whole host of employment laws, and it's very hard for someone starting out that hasn't been involved in determining who's an employee and who's not, and in determining exactly how to pay someone, to be able to negotiate and put together a plan that best protects them from legal liability down the road.
Well, so it sounds like there's potentially a couple of tracks in terms of the documentation that you need if you're starting out and you're employing folks, and it covers both your area and then also Kathy. Like, how do you even establish a payroll? I mean, what does all that look like? And does that comment or question make sense as between the two of you?
Yeah, we have, especially in starting out, so many people, to Jennifer's point, think that everyone can be on salary, like the ease of salary, and it's really not appropriate. And they sometimes just start writing checks to people who are assisting them.
Right.
And don't know that they need to get their personal information, that they may be actually employees and not contracted workers. We always advise anyone who's starting out to actually outsource your payroll. There's very good payroll services. They're very competitive. So that's my advice. They can also give you good advice in terms of the documentation that you need for all of your employees. There is a lot of documentation that's required by the law just in setting up your payroll files. And in addition, making sure that you have them classified appropriately. So again, to Jennifer's point, what seems like such a simple thing, those of us who have just been getting paychecks, to all of a sudden be the employer who's responsible for paychecks and payroll, even selecting your payroll periods, getting your quarterly tax returns filed and the W-2s filed. It's a job that you probably will need assistance with.
And I'm going to jump in real quick. One of the things that Kathy was talking about was documentation. And at the beginning of an employment relationship, there are certain documents that employers have to have. There's other documents that they should have. And one of the things that you have to have as an employer very early on is an I-9. If you have a worker, they have to complete an I-9 generally within 3 days of their hire date. And if you're only hiring them for less than 3 days, like a temporary worker, that I-9 needs to be completed before the first day is over. So there are a lot of documents that are required. One thing that those that are online might be interested in is a lot of the government agencies, they have websites with training, webinars, fact sheets that help at least give you enough information to know what questions to ask. For instance, the U.S. Citizen and Immigration website, they have a webinar on I-9s. It explains what is an I-9, how do you complete an I-9, and it provides the limitations. So for instance, it explains that you can't tell people what documents you want to see in order to complete their I-9, but instead there's a list and they can bring anything they want to as long as it's on that list. And that's not the only helpful website that's out there, but it still is important to consult with someone to make sure you have a good plan in place for bringing workers in and paying workers. And in developing that plan, obviously looking at important websites with respect to employment, it's not going to be an answer to all questions, but it will at least give you context and framework in which to ask your advisor, whether it be a tax advisor or a legal advisor, about what you need.
So far we've heard about the documentation necessary when you set up the entity or make your selection, documentation necessary for the establishment of the pool of employees, also with regard to the taxation, the selection of taxation and whatnot. So let's talk about the intangible. So Liz, you were saying the other day, it seems like a lot of small business owners feel like they don't have intellectual property. That's the province of like an internet company or somebody who's patenting something, and gosh, why do I need that, or how does that touch me? The reality is that everyone in business has intellectual property, and there are different issues depending on what you're talking about. So can you give us kind of the broad brush stroke that you would be thinking about if you're starting a business?
Sure. So I think it's helpful to give just a general overview of the different types of intellectual property and how they can relate to businesses. So the first one is trademarks. Trademarks really protect anything that can serve as a source identifier. So anything that when you see it or hear it, you think of the source, you know where it came from. And so let's take Nike, for example. Nike has their name, their logo, the swoosh, and the slogan, just do it. All three of those things, when you hear them, you see them, you think of Nike. And really every business has that. Every business has a name, its own name or its product name or a logo that they could protect, trademark law. Another area of IP is copyright. Copyright protects original creative works. So that could be the product that the person is creating. So if you're an author, painter, designer, photographer, but also it can cover things that you just create in the course of your business. It could be the design of your website or your social media posts, or if you're writing articles, or even your logo again. So I talked about how a logo can be trademark, but it could also be protected by copyright too. The third area of IP is patents. So patent is what most people think of when they think of IP. That protects useful inventions. And so again, that could be your product that you're selling, but it can also be something that you come up with in the course of your business that just makes it run better. So it could be a good or a machine, but it can also be a system or a process that you come up with. And then the last area of intellectual property is trade secrets. So that generally protects anything that is not known outside of your business, that gives you value because it's not known, and that you take steps to keep secret. So that could be your marketing plan or your pricing structure, your customer list, anything that somebody outside of your business wouldn't know that brings you value that you take steps to keep secret. So all of these things interact in different ways to really protect all different aspects of a business. And some of them overlap, some of them are alternatives, and they can all be really important assets. And I want to mention on the intranet side, that's opened up a whole new world for companies. So now you have your website, your domain name, your social media accounts, the content on the accounts. So those can all be protected in their own ways too. And so there's this big group of assets that really work to protect a business, its goodwill, its products, everything they create in the course of their business. And every business has some combination of those things that are important to it. So it's important to think about it and protect them.
So that sounds both important and expensive. So are there options for protecting your IP that don't involve huge legal bills? Not that I'm trying to put us out of a job, but you know what I'm saying. I don't want to scare off those entrepreneurial spirits out there.
There are many different considerations here. So some forms of intellectual property can actually be protected without a registration. So for example, trademark rights can be protected just by using a mark in commerce without a registration. The downside is that you only get limited protection in the geographic area where you're using it, and only if you're the first one using it there. So while you can generate trademark rights and you could enforce those if the time came, registration is beneficial. The same goes for copyright. A copyright is created immediately upon the creation of the work. But the Supreme Court recently held that you can't sue somebody for copyright infringement unless you have a registration. So again, even though the right exists, if it's important to you and you plan to enforce it against other people or protect it, it's really helpful to register that copyright. Trade secrets are, there is no filing for them. As I mentioned, you have to keep them secret. So that's really important. You need, Jennifer mentioned this with the employment documents, but you need documents with your employees to making sure you're keeping things confidential and that you're taking steps to keep things secret. And then you need to have your own internal practices too, where you're marking things confidential, you're putting passwords on things, locking things in secure drawers. That is really what you need to do to protect trade secrets. So, and on the trademark side too, I should have mentioned there is a state filing, which can be, it can be cheaper than the federal filing, but it also gives you less protection. So there are all different ways to protect intellectual property, and it's important to think about what intellectual property are you generating, what's most important to you, and what's the best way to protect it.
Okay.
And I'm going to jump in real quick. Liz mentioned non-compete agreements, confidentiality provisions. Those are important because if you have employees working for you that learn your systems, your pricing, and they understand the way you run your business, and you don't have something like that in place, they could go start a competing business. And they can take all the work that you've put into developing this new idea and becoming a success and become your main competitor. And in Florida, these types of agreements are permitted. I mean, obviously, the higher level the person is in terms of the organizational structure, the easier it is to enforce. If you have somebody who is performing menial tasks, that's not something that a court is necessarily going to enforce. But it's important to think about, am I doing something new that I want to protect? Or am I entering into a industry that already has a lot of competitors? I just have a different idea on how to approach it. And these types of agreements can be at different levels of protection because there's a lot of different covenants that you can select to put in to make it as broad or as narrow as possible. But it is something to think about when you have a great idea and decide to start a business in order to implement that plan.
You know, Tom and really Liz and Jennifer, that just goes to my way of thinking of making sure you always talk to your advisors when you have these great ideas, because you could also be eligible for the R&D credit. A lot of folks don't think about it until, kind of down the line, but we need to make sure that we're documenting all those expenses and the procedures and the processes. So, even you talk about intellectual property and the development of things that are unique to you and your business, you could actually be eligible for credits that you're not aware of as well.
Wow. So Jennifer, so you're talking about non-compete agreements. Is there a general need for contracts with your employees, or what can you speak to on that subject?
Well, generally, again, this is an at-will employment state, as I said at the beginning of our program. And for employers, that's good. If you're not happy with someone, you can stop that relationship. When you enter into employment contract, you are changing the at-will employment relationship. And there's specific requirements for employment contracts in Florida. They have to be if they're for over a year, they have to be for a designated period of time, and they have to be in writing. For most employees, would suggest more having an offer letter that outlines the initial terms of the employment relationship, but doesn't create a contract that's enforceable. However, if you have high-level executive employees that are very important, that you cannot really go without at a drop of a hat, that is someone you might want to put into a contract where you have notice provisions, and there can be enforcement provisions if they violate that contract. The flip side of that is when you have a contract like that and you want to get out of it, you can't just do what you want. You have to make sure that you're terminating that contract in accordance with the provisions that are set forth within the document itself. And usually when you're dealing with someone that's that high level and that's that valuable, you're going to end up paying severance of some sort, because they usually are like, well, I'm coming in, I'm telling you I'm not going to leave you, I'm telling you that I'm not going to find someone else to replace you, someone else to employ me during this time period. And as a consequence, if you separate the employment early, employer, you're going to owe me something. So those are different considerations.
So the answer to the question of whether you need a contract is typical lawyer answer, it depends.
Yes, exactly. Very good.
Good. Well, okay, so here's a really excellent question that came in, and I think, Kathy, you had anticipated that this would come in, and this is directly on point. How do you pay yourself? So the specific question was, for an LLC filing as an S Corp, what are the percentage guidelines in paying the owner's salary compensation versus profit net income distribution? I don't know if you're going to get that granular, but you're obviously in business to make money. So what do you do?
Yeah, as you probably know, if you're asking the question, that is one of the IRS target areas, because there is a lot of, there are many problems with the area, and especially with some of the credits that we get, the deductions we get with QBI. You must pay yourself a fair value for the services that you're providing the company. Mm-hmm. In my case, many of my clients are physicians. Lots of them are in S corporations. We make sure that we get market surveys so that we can properly figure their compensation. Mm-hmm. So I advise anyone who's in business, who's anticipating trying to figure out what their salary should be, to bench it at maybe what you would pay somebody else in the same job, or there are just a lot of different market surveys that you can access and use. You need to have proof. I have seen in audit that the IRS is absolutely looking for that. I had a client who took a sabbatical and took on a different number of hours while she was on sabbatical, and they tried to take distributions and reclassify those as wages. But we had adequate documentation that was you know, her intention, and we had timesheets and things like that for defense. So we didn't get in trouble in that case, but
Mhm.
it's certainly one of their audit questions, and you need to be mindful of that.
So switching gears a bit to Liz, a question came in regarding ownership of patents, and perhaps maybe you can break the question down a little bit, because I think that kind of piggybacks off of where you were going about protecting your intellectual property and what constitutes the IP.
Yeah. So the question came in, it was asking about co-inventors in a patent owning, all of the inventors owning an interest in the patent. And this is something that comes up a lot in terms of ownership. People assume, you know, oh, if I paid for something, I own it, or if I invented this particular part, I own this particular part. That's not necessarily the case, and it's especially tricky with patents and copyrights. So for patents, default is the inventor automatically owns it. And if there are multiple inventors, if there's no agreement to the contrary, all of the inventors own all of it. They don't just own their individual piece, and they can exploit it individually. And on the copyright side, this comes up a lot too. People, you know, people hear the phrase work made for hire, you know, they assume if I pay for something, I own it. And that's not the case. The default is in copyright that the author originally owns it. And so this comes up a lot with employees and contractors. If you're an employee within the scope of your employment, creating copyrightable work, the employer would then own it. It would be a work made for hire. But the tricky part comes up with contractors, because most people, a lot of people don't hire employees to do their creative work. They hire a marketing person or an outside IT person to run their social media or their website. And then you don't fall into the default work made for hire. There are several rules you need to meet for it to constitute a work made for hire. It has to fall within one of 9 very limited categories. I won't bore you with the details, but it includes atlases, instructional textbooks, tests, answer keys for tests. I mean, very specific things that you rarely will fall into. It has to be in one of those categories. Even then, you have to have a written agreement saying it's a work made for hire. And there's a split in the courts about when that agreement needs to be signed. So some courts hold that even if you have an agreement signed after the work is created, that's not good enough. So all of these things are really working against you in terms of ownership. So it's important to think about upfront. There are a lot of benefits to something being a work made for hire. In addition to the ownership, it gets a longer term of protection, and it's exempt from the termination of transfer provision. The Copyright Act has a rule that any assignment of copyright can be terminated by the author 25 to 30 years after they transfer it. And it's non-waivable. There's nothing you can do about it. So if you don't automatically own it and you only get ownership by assignment, this person can pop up later and terminate your rights. So it's really important to think about all these things up front. Make sure you own the intellectual property that people are creating for you. And I know Jennifer has a lot of considerations on her end, but from my perspective on the IP side, if you have people creating important intellectual property for you, I would encourage you to think about making them employees, treating them as employees. The ownership is so much clearer. Either way, have an agreement in place that sets out everyone's ownership rights, how you can use them. Circling back to the question, if you have an agreement in place that says, no, only one person owns it, or I only have the right to exploit it, or you're not allowed to sue me for infringement, you're allowed to change things by contract. So think about putting contracts in place that set out very clearly everyone's ownership rights, everyone's obligations as to third-party IP. If you have employees bringing in IP from other places and you don't want to be sued for infringing their former employees' IP or other third parties' rights, that can all be handled in the document. And the last thing I want to note is just there are a lot of state law issues here too. So there are several states that have their own rules about how you can and can't take assignments of intellectual property from your employees and contractors. So if you have people in multiple states, I would look out for that as well.
So kind of like in my area of practice, it's all about location, location, location. The theme that's really coming into view with what the three of you are saying is document, document, document.
Yes.
Right.
All right. So in that regard, I have 2 very basic questions, one for Jennifer, one for Kathy. For Jennifer, do you need an employee handbook? And for Kathy, what is a good baseline of accounting records so that the Kathys of the world can prepare a tax return? So whoever wants to go first.
Well, I'll jump in. There's no law that requires that you have an employee handbook. Employee handbooks are used right now for two basic reasons. First, to communicate to employees what your expectations are of them and to provide them with information about what they can expect from the employer. On the other hand, you have employee handbooks that are designed to try to protect from any type of legal suit that might come in. And as you can imagine, when you start going in that direction, your employee handbooks become very, very large. I usually recommend consider the size of your business, evaluate what laws apply. So if you have under 50 employees, you're not going to have an FMLA policy, even if you have a employee handbook. However, if you have 50 or more employees and qualify as an employer under the FMLA, at that point, you would be required to have an FMLA policy in the handbook if you have one. So it's really it is a good idea to provide expectations. However, make sure that you're writing a handbook or you're having a handbook written for you. That is one the employees are going to read, because those policies are no good unless people read them. So if it's too complicated, obviously in one ear, out the other. Number two, make sure it addresses things that actually take place. I see a lot of employers will come in with handbooks that they got from someplace else. And it might even be a computer company, and you're looking at the handbook and it's talking about laws that only apply to healthcare providers. So, and when you provide handbooks like that to employees, they're going to be looking at it and be like, the employer's wasting my time, and they're going to stop reading. At the end of the day, it's very, very important to have a couple things if you decide to have an employee handbook. Number one, you need to make sure that you explain how payroll works, because people work to get paid, and that's what they want to know about. When am I going to get paid? How am I going to get paid? From an employer's perspective.
Yeah, I was going to interject that.
Right.
We're 40 minutes in.
From an employer's perspective, you're going to want to tell them how they're supposed to track their time, what happens if they don't do it correctly, and then you're also, this is toward you, Kathy, you're going to tell them what is going to happen if there's a mistake, and you're going to tell them about the deductions that are going to be made pursuant to applicable law. Aside from payroll, it's important to have expectations on how you want your employees to interact with customers and with others. And then at that point, do have policies that not necessarily go into great detail, but just cover the laws that apply to the organization. So
I always recommend that my clients get handbooks because, you know, things may not always escalate to the point where they have to see an employment attorney, but they certainly alleviate a lot of issues that we have often in the payroll realm. Just your basic, it also makes the employer think about things in a proactive way. So sitting down and going over either maybe their payroll company or an attorney or an accountant at least gets them the basics of, I have this deduction, I'm going to pay, you know, this many times, you know, this is my vacation policy. Even something as seemingly simple as how I accrue my hours for vacation policy, it's because when people start getting into problems, you know, that's when things and other issues that again may or may not be problems come into play. So Jennifer, I actually think everybody should be talking to someone.
Well, I agree, but it's not required by law. It is good. I mean, honestly, if you take a look at employment relationships, it's like any other relationship. One of the most important things is communication. And if you don't communicate, you're going to have problems. So your handbook is a form of communication to talk about expectations. And so it is recommended that you have one, but is it required by law? No.
So Jennifer, let's veer off for a moment. Obviously the work at home issue is quite current, given what's been going on in the world, and I think it has brought to the forefront a variety of concerns, questions, et cetera. Is there any way you could give us just kind of a brief look at what's on your mind about that and what a potential new business owner or existing business owner should be concerned about?
Yes, although this could be an entire day seminar, as these
Also,
issues
so the challenge is on for you because we're at 10:42.
So basically with at-home work, there's a few different things. And first off, if you have an employee, how you handle it from a wage perspective is going to be determined by whether or not the person is exempt or non-exempt under the Fair Labor Standards Act. And exempt versus non-exempt basically is a determination on whether someone's entitled to minimum wage and whether or not they're entitled to payment of overtime. Because if you have a non-exempt person, and that is somebody that is entitled to minimum wage and overtime, then at that point you have to make sure to have accurate records about the time the person is working. And that is sometimes difficult when you're working from home. And that is another reason, going back to our prior conversation about handbooks, is it's another really good reason to have a handbook, because in that instance, it will address timekeeping. Another thing to keep in mind is a lot of handbooks that were written prior to the COVID crisis are ones for employers that normally did not anticipate or want to have workers that are at home, and now they're at home. And one of the things that we've been recommending to our employers is that they have telecommuting agreements. It's not an employment agreement. It doesn't change the at-will relationship. It's another means of communicating to the employee what your expectations are and explaining to the employee either when they're supposed to work, if there's designated times, the number of hours they're expected to work, and how they're supposed to track their time, in addition to reaffirming any confidentiality provisions. And it is really important to have that in place so that down the road, if someone shares confidential information, you can say you knew, and they can't say, oh, I didn't know that applied from remote work. So that's one of the issues that's starting out from the forefront. And there are some existing and some new programs that are coming out there. There's phone systems that you can clock in and clock out through your phone. If you're doing remote work, you can just get on and clock in the way you would if you were working at your desk. Those are some of the more pressing matters. There's also questions with respect to workers' compensation. If a person is actually working from home, then workers' comp does come into play. It gets a little bit more complicated. And for instance, if a person was actually working and got up to get coffee, which they do at work too, and trips over a cat, and breaks their ankle, is that something that's going to be covered by workers' comp or not? I don't know. We're still trying to figure that one out. If it's one where you really consult with a workers' comp insurer, but it is something to be concerned about. And it is something that if there's anything that you can do as an employer to communicate, be safe, do what you need to do, that's always a good thing.
So it sounds on that issue, work in progress, obviously. Getting back kind of higher level in terms of documentation, there's a lot of, sounds like need for a variety of documentation, some of which it seems is possibly somewhat rote in terms of the information that the advisor needs in order to prepare the partnership agreement or the employment agreement, et cetera. So maybe Liz, if you could speak a little bit to how do you develop the information from the client? Is that something that they just go on the internet and get some questionnaire and pass it to you? Is it a specific conversation that you're having depending on the need?
I'll give the lawyer answer. It depends. So it's always a case-by-case basis on what their needs are, who the players are, what their relationship is. Is there one person who's bringing all the money and one person who's bringing all the skill? What are their plans going forward for building the company? What is their end goal? Do they want to sell or pass it down to their families? So we'll talk through all of these things with our clients, but typically, big picture, the things we generally want to cover in our agreements are, what is everyone's obligation to put in money to the company? Is everyone putting in money? Are they providing services? Are they providing hard assets? And some of those have different tax considerations. If the company needs more money, where is it going to get it? Will the people put more money in? And if so, what is their obligation to do that? Can they take out loans? Can the members make loans to the company? And what do the terms look like? Who controls the company? Who's going to be operating the day-to-day operations, making the decisions, signing the contracts, and who has control over the big picture issues? If you want to sell the company or sell its property or take out a loan, over a certain amount, does somebody need to provide extra approval over the president or the managers? One of the other big areas we talk about is transfers. Who can people transfer their interest to? Do you want them to be able to just turn around and transfer it to their neighbor or their kids or their spouse, or God forbid somebody gets divorced? Do you want to be in business with their ex-wife or ex-husband, or do you want to be able to pull those units back?
Incapacitated. They can't act
I'm
on
sorry?
their own. What if someone becomes incapacitated and they can't
Exactly.
they can't themselves?
So all of those things are important to think about, and it's helpful to think about it up front when everybody's friendly and coming to the table, so that you have it on the back end should anything go wrong. If we ever need to pull that document out and see what the agreement was, it's really helpful to do it now so that you have it for later.
And would it be fair to say, and tell me if I'm totally off base, is it similar to the concept of, if you decide not to make a will, for instance, you've effectively made the decision that Florida law is saying what's happening with your estate and your assets, similar to an entity? Say you go online, you set something up, you have no agreement amongst the co-owners, you effectively have decided that Florida law is going to say what's going to happen.
That's exactly right. So for LLCs, which is what we often form, that you can have an operating agreement which sets out all of these terms, but if you don't, the default would be the LLC Act under Florida law. And oftentimes that doesn't come up with the result that the client wants. Right. So that's why it's helpful for them to really talk about these questions, and then we can put them down so that that is what governs at the end of the day.
Right, because that statute covers a lot of ground, but not necessarily the ground that you're talking about.
Right, it doesn't think about everything, and the things that it does address aren't necessarily in the way that people want it to.
Right, right.
And I want to jump in. Liz had said something about finding documents online and doing stuff online. And one of the things that we see in our employment section is a lot of times companies will go online, and we already said find handbooks, but they'll find employment agreements, they'll find all sorts of different documents, they'll find non-compete agreements, and they use them, but they might not be agreements that are in accordance with Florida law. And one of the things I saw recently, which I didn't understand because it is a federal problem, was an agreement that said 1099 employment agreement, which in and of itself, it doesn't exist. A 1099 goes to a contractor. Employees get, the W-2, W-4, and it's like, well, you can do your initial research online to help you ask questions, but at the same time, you still need to be wary before implementing anything that you find online, whether it be from an employment perspective or a tax perspective, or just your startup and your business documents.
Hey, they do that in the real estate world too. Hey, Kathy, this might be the silliest question, but so say you've got a job, and then you develop the side hustle. Are there any particular tax concerns if you're employed on the one hand, but you're an entrepreneur on the other hand, or is it just one big happy mishmash and Kathy gets to sort it out later?
A lot of course, you need to talk to your attorney about, whether you want an LLC. But from a tax perspective, we usually start simple, particularly if you already have a job and you just have this little side thing going. It's usually you and maybe a spouse or something, but usually not, just you.
Mhm.
Please say, let's start with just a Schedule C. Many of our clients have the wrong impression that they don't get good tax deductions unless they have a, they call it corporation.
Mhm.
And I don't know if they confuse corporation with LLC, but it's really not true. And in fact, if you're working from home and you have a very simple entity, it's actually better to file a Schedule C because you get the home office deduction.
Mhm. Mhm.
And that's a really great deduction. It gets you transportation to and from clients or jobs right from your home too. So
Mhm.
that's where we usually start. You can get lots of great deductions. You're not going to see much difference. As you get more complicated, complex, we may want to talk about an S corporation, but the initial start for most of those companies would just be the Schedule C.
Gotcha. Okay. We don't have an insurance professional on the panel, but Jennifer, maybe I think there's possibly an area where that's possibly an area you may want to speak to, the necessity of I think there's certain kind of policies that are available in your world that may be something important to touch on.
Yeah, there's something called employment liability practices insurance. It's becoming more and more prevalent as the Morgan and Morgans of the world become more active in filing suits against employers. And there's pros and cons to these types of policies. The pro obviously is once you meet your deductible, you have insurance coverage to take care of, at a minimum, your defense costs. Some of the policies even go beyond and provide coverage for all potential liability aside from punitive damages.
Mm-hmm.
The downside is you, to some degree, lose control when you have these types of policies. You may not have the attorney you want. You might have one assigned to you. And that assignment, because of a lot of times these policies restrict fees, which is also good, but you end up with a much less experienced attorney in many cases working your matter and defending a claim against you. And in addition to that, once the deductible is met, if there is a good offer in the eyes of the insurance company, there's something called a hammer clause, where if they feel there is a very good settlement offer that should be accepted by the employer and the employer doesn't, they have the ability to come in and just say, we're not covering anymore. You can defend on your own. And in that case, what's the point of having the insurance in the first place? But as individuals are planning their businesses or reevaluating where they are, it is something to consider. Whether or not you decide to do it is going to be a case-by-case basis, depending on your company, the number of employees, the likelihood of a potential suit, the types of claims that actually apply. Because if you're a very small employer, you might not have a lot of liability because if you don't have 15 or more employees, you're not going to be liable. You're not going to be an employer under Title VII. If you don't have 50, you're not going to be liable under the normal FMLA. So those are factors that go into considering that. But it is something to think about and to make a decision knowing all the risks and benefits of having that insurance.
Got it. Hey, Kathy, so you're starting a business. Is there a checklist of items that are tax deductible?
Not exactly. We do try to go through the client's business model and point out things that they should definitely be aware of. A lot of it is just common sense. The IRS says ordinary and necessary. Well, what is ordinary and necessary? Those are expenses that would be common in their field. The IRS does have some good publications if you're the type that feels like you need to read everything before you talk to your advisor. They have one publication that's specific to the individual with that at-home business that we just chatted about, including what you would need for home office deductions in order to make sure that you actually got it. And then they have another one that's designed mainly for S corporations. They actually have all types of businesses, but the two that we see most would be the S Corp and the home-based or, sole proprietor.
Okay.
Maybe a partnership, but they have a checklist, or it's not a checklist, it's just advice as to how they need to report. And I do want to say that it is really, really important to everybody who's starting a business or in a business, make sure that you keep receipts for everything. You need to keep receipts for 7 years, and that's your sales receipts, deposits, as well as expenses. It's not just your expenses. Also,
It sounds like an awfully big shoebox.
yeah, put them away somewhere. You can scan now. I mean, we have technology. Also, any big box purchase, Target, Publix, Costco, Amazon, we cannot use just your credit card statement in an IRS audit. They love that. They will absolutely 100% disallow those expenses unless you have the receipts. And the receipts need to be, I mean, we've seen it all, but it really should be ordinary and necessary.
Got it. All right, so we're rounding the corner to almost an hour, and I started with Liz, and so Liz, I'm gonna ask you to get on the hot seat one more time. Talk a little bit, and this is kind of a general question, but everyone is expected to have a website and be online these days. Anything in particular you want to share with the group when you're starting a business and you've got that cool new website?
Sure. So there are a lot of considerations now. The digital age just has opened a whole new door for businesses. So in particular with your website, think about all the documents you might want to have for it. So terms of use, which would govern the way people interact with your website, what they can and can't do on it, what your obligations are to them for it, and what your liabilities might be. And privacy policies are a really important area these days. So making sure you're being upfront with people about the information you're collecting, why you're collecting it, how you're using it, how you're disclosing it. It's a really active area for the FTC and other states right now. And it's especially tricky because the law that applies isn't necessarily the law where you're located. It sometimes can be the law where the person visiting your website is located. So that could implicate all other states and countries' laws too. So it's a pretty far-reaching area. And another issue is if people are able to post to your website, you need to be worried about copyright infringement. So if they can post content or pictures or videos through an interactive chat or comments, or even if you're using user-generated content on your social media, you need to be worried about copyright infringement. There are some benefits under, it's called the Digital Millennium Copyright Act, to shield you from liability, but there are certain steps you need to take to comply with it. And the last thing I'll mention is the ADA, Americans with Disabilities Act, is a huge area of liability right now. Companies are getting sued because their website isn't accessible to people with disabilities. So if they're visually impaired and they can't use a screen reader on their website, or there are certain best practices to follow to make sure that you're complying with it. It's a really active area. A lot of people are getting sued. And so that's something to keep an eye out for as well.
And that applies to all businesses, I assume.
Yes, it applies to all businesses.
Okay. All right. I think we are at exactly an hour. So unless I see any hands flailing in the background from the panelists that we've missed something big, I think we'll go ahead and thank everybody for their wonderful input. I think we ping-ponged around a little bit, but I think hit home the point that how important it is to make sure that your house is in order, whether you're starting a business or if you're somewhere along the continuum. We certainly hope that everyone attending has stayed well and their businesses have stayed healthy too. I think we're going to post on the screen contact information for the individual panelists. So if there's anything that you want to speak to in more detail with them, this is the way you get in touch with them. Of course, if you lose the contact information, you can always just go to williamsparker.com or kbgrp.com for that information. But we appreciate you spending some time with us today. Thank you to Liz, to Jennifer, to Kathy, and we wish everyone a wonderful and healthy weekend. And please join us again when the time comes. Thank you.
Thank you.
Thank you.